The Model Code on Indian Family Law is a comprehensive, gender-just, and queer-inclusive code. It is a template for what a progressive family law code can look like for India today. This code is supposed to serve as a template or a resource to aid public deliberations on family law reforms. The manner in which family law must be reformed, of course, must be democratically deliberated upon and based on consensus. Some of the key values in forming our code are, of course, the Constitution, values of equality, dignity, liberty, and non-discrimination. We were also very participatory in our process, and we engaged with several progressive movements, specifically the women's movement and the queer movement. And finally, the Model Code focuses on a functional definition of a family. That is, what should a family do, which is provide mutual care and dependence, as opposed to the form of a family, which is what should a family look like. Some of the key features of our code are inclusion. Under the code, everyone can form families irrespective of gender identity, sexual orientation, or marital status. We have also made space for atypical intimacies in our code through the recognition of stable unions. So this makes space for non-romantic, non-conjugal, and non-sexual relations within the family law regime. The second key feature of our code is gender justice. We have provided for this through robust provision on maintenance and the introduction of matrimonial property. We have also accounted for women's invisible labor in this process. And in order to include all gender identities, we have shifted from only gender identity as the basis of vulnerability and provided for a list of factors on the basis of which vulnerability can be determined. The third key feature of our code is that of protection. Protection is ensured through provision of equal inheritance for all, irrespective of gender identity, through introduction of provisions that prevent from disinheritance, and finally, through centering of the child's agency and autonomy in decisions impacting them. The final key feature of our code is that of modernization. We have enabled modernization by shifting from the outdated regime on guardianship, which determines parent-child relations in India, to one of parental responsibilities and rights. And we have attempted to modernize the rather outdated law on wills in India. Two ways in which we have enabled that is through provision of digital wills and digital witnessing of wills as well. We are very excited to have this very important conversation at this very critical juncture. I would now like to take a minute to introduce our esteemed speakers for the roundtable. We are joined today by Honorable Justice Sanjay Kishan Kaul, who is a former judge of the Supreme Court of India and was a part of the Suprio bench in the marriage equality matter. Dr. Bina Agarwal, who is a professor of development, economics, and environment at the University of Manchester, and has written extensively on inheritance and property rights for women. Advocate Malavika Rajkotia, who is the founder of Rajkotia Associates, which is a leading divorce law firm in India. She litigates extensively on family law matters before courts in New Delhi. Professor Madhavi Menon, who is a professor of English at Ashoka University and works with questions of sexuality, desire, gender politics, and identity. Dr. Sourav Mandal, who is an associate professor at the Jindal Global Law School and also an associate editor of the Jindal Global Law Review. Ms. Zakia Soman, who is one of the founders of the Bharatiya Muslim Mahila Andolan and who was also a petitioner in the Triple Talaq matter in the Supreme Court. Professor Chandra Oraon, who is an assistant professor at the National University of Study and Research in Law, Ranchi, and who works extensively on the issue of customary laws. Dr. Saumya Saxena, who is an associate professor at the Jindal Global Law School. Her research interests include legal history, family law, and gender and politics in South Asia. And finally, Mr. Anish Gawande, who is the founder of Pink List India, which is the country's first archive of politicians supporting LGBTQIA+ rights. Thank you, everyone, for joining us today. I'll just pass on to Orgho, our research director now.
Thanks very much, Namrata. It's a real full house, and I welcome everybody on the panel and in the audience today for what is a critical discussion at a critical juncture. When I was reading the Suprio judgment, one line really resonated with me, and I'm going to quote it. Quote, "The next step in due course would be to create an edifice of governance that would give meaningful realization to the right to enter into a union, whether termed as a marriage or a union." And the reason, unquote, the reason that resonated with me was that for the last 1.5 years, together with my colleagues at the Vidhi Centre, we've been working on what we believe is a progressive and gender just family law framework. This is, of course, ambitious. We are cognizant of the level of ambition and also aspirational, but we thought that the discussion should move towards a legislative framework that could be a future that we could all aspire to in India. And I'm delighted today that we could have this discussion. And for this discussion, as a keynote speaker, we have the author of that line, Justice Sanjay Kishan Kaul. Usually there is a big introduction that follows, but I am not going to introduce him any further. I'm not going to use another but here. I'm just delighted, sir, that you could be here today. And I'd now like to invite Justice Kaul, together with everyone else on stage, to first please hold up the first copies of the model code on Indian family law that we have for you today. Thank you very much, Justice Call. There will be copies that are available outside. It will also be available on our website. So this has a full code on what we think a future family law regime of the kind Justice Call was adverting to can look like. So without any further ado, I would now invite Justice Call to give his keynote speech.
Very good evening to you, and thank you for calling me here. I've often found myself on the same page as Mr. Singupta in terms of many of his writings. And the lighter vein, I suddenly realized I'm wearing the same shirt as he is. So, future of family law reforms in India. This issue is extremely vexatious because of the intertwining which goes on in different aspects. And a large part of it is due to the great number of statutes governing various aspects of family laws, which referred to in the Constitution when decision is superior as a spider's web of legislations. In the context of a non-heterosexual marriage, in my opinion, well, I had underscored the difficulty that the court faced in the presence of this web of statutes, each of which presents a larger, more deeper form of social discrimination that is pervasive as a structural nature of our society. No doubt the level of discrimination that persists requires some judicial scrutiny, but the courts have their own limitation by institutional capacity, which we faced in Supriyo's case, in some extent, even the minority view. The larger aspect should be in the legislative domain, and this endeavor is certainly one in that, in trying to see what are the complexities are. I will certainly go through it. I've not had the benefit of going through it. In Supriyo, the Chief Justice and I endorsed the need to implement a separate anti-discrimination law, which inter alia prohibits discrimination on the basis of sexual orientation. While there are statutes that have an anti-discrimination aspect, they are fragmented and much is left wanting in terms of capturing and addressing the forms of discrimination. As I point in the same-sex judgment, there exists compelling reasons for law that places a horizontal duty on anti-discrimination, provided by the spirit of Article 15, which prohibits discrimination by both state and private actors, particularly in view of the challenges faced by the marginalized communities to access remedies that are available in law. Therefore, the proliferation of remedies through an anti-discrimination statutes may be possibly a fitting solution. Such legislation would also be in the furtherance of a positive duty of the state to secure social order and to promote justice and social welfare under Article 38 of the Constitution. I had proposed the following suggestions that the legislature may consider when enacting an anti-discrimination law in that context. Firstly, such a law should recognize discrimination in an intersectional manner, and discrimination must be looked at as a confluence of factors, as identical and individual instances of oppression that intersect and create a distinct form of disadvantage. I often believe this is true of any form of law or any form of a problem. First is an acknowledgement and then is a solution. Often there is lack of acknowledgement in the existence of a problem. So the solution itself goes that much far away. Number two, discrimination laws can only be effective if they address the types of inequality that have developed in the given society, as also held by the Supreme Court in Navtej Singh Johar. Thirdly, the duties under an anti-discrimination law can be proportionately distributed between different actors depending on factors such as nature of functions discharged, their control over access to basic resources, and the impact on their negative liberty. Fourthly, an anti-discrimination statute must also enumerate methods to redress existing discrimination and bridge the advantage gap. An anti-discrimination law will also address the deep-rooted issue that plagues family law in India, which is a patriarchy. The Supreme Court, in order of reference of issued constitutional validity in Section 497, as far back as 2018, had aptly observed that the provision grants relief to the wife by treating her as a victim, and while ordinarily criminal law proceeds on a general neutrality insofar as Section 497 is concerned, such concept was absent. The court was also of the view that once there was a consent or the connivance of the husband, no consequences follows for the wife, created a dent on the individual independent identity of a woman. This amounts to subordination of a woman where Constitution confers equal status. The court went on to observe that the time had come when society must realize that a woman is equal to a man in every field. This provision, prima facie, appears to be quite archaic. When the society progresses and the rights are conferred, the new generation of thought spring, I unquote. Instances of family law being favorable to husband, male members of the family abound, which ought not to be a case and require legislative intervention. Lord Nicholas, in the celebrated decision in White versus White, had recognized that there should be no bias in favor of the money earner and against the homemaker and the child carer. Even the expression a homemaker developed over a period of time from saying that he's a housewife. That's one of the indication of the change. Similarly, it was in 2005 amendment to the Hindu Succession Act that the co-parental right vested in the female member of the family and was recognized. And last year, Delhi High Court recognized the right of a female member to be Karta of the HUF. Let me say this, changes of law are sometimes easier to make, but changes in the social thinking process much longer. I've seen in courts, even after change of law, the perception of, in a litigation of the male members that, well, what the daughter had to be given has been given. Why does she want to share in what was kept for me? And that man truly believes, he's been bred and brought up with that view. So anything contra which law confers, he feels is an infringement to what his rights are. Now that's a mental thinking process. So a sister demanding a share from the brother is supposed to be anti-family. So that's how the thought process has taken longer to change. The continuous forays of court in positive direction is also seen in the case of divorce. In Naveen Kohli, the Supreme Court held the situation causing misery should not be allowed to continue indefinitely, and that the dissolution of marriage that could not be salvaged was in the interest of all concerned. Personally, I believe that the marriage is an important institution, that every effort should be made to uphold the marriage institution. But if two people cannot get along, I find it a fruitless exercise of continuation. As a Supreme Court judge, I found a very wide spectrum of the family situations from which these cases come. If you see practically every bench of Supreme Court, almost every day has what are called the transfer petitions. 99% of the transfer petitions are only outflows of matrimonial problems. A very large percentage of them, in my experience, are marriages which are almost under 3 years of existence. And they are all kinds. They are love marriages, they are family arranged marriages, etc. Just that sometimes two people have not got along. This is something I've emphasized, and I've utilized Article 142 quite liberally to bring such associations to an end. Maybe this irretrievable breakdown of marriage, which is conferred only on the Supreme Court, needs a legislative look. Previous attempts have not been successful. I believe one of the reasons of lack of success is the feeling that the women gender would be in a disadvantaged position. So, irretrievable breakdown of marriage must come with equality of share of wealth between the two parties. If that happens, I think the fundamental reason why irretrievable breakdown of marriage has not been incorporated can be addressed. In Amardi's case, the Supreme Court emphasized that the cases of divorce by mutual consent, the cooling off period mentioned in Section 13b(2) may be waived in a situation. While expounding on 13b(2), the cooling off period prescribed then being discretionary in nature and not mandatory. There have been situations where parties have come to court and said that, please let us go. I've had a scenario where a woman appeared in person and said, look, I don't want any alimony, I don't want anything. She's a working woman, but please relieve me of this situation. I have an opportunity to go to the US for further education. I don't want to be tied up. So forget anything else which has to come. I'm willing to forego any so-called right of maintenance or division, but as it is, let me go. So this is the scenario which evolves. On the other hand, there are also scenarios where I feel problems are evolving from the nature of social relationships. For example, not only in cities, but major cities, metropolitan cities, but even in smaller cities, the concept for people living together has grown. Now, what is the challenge in that? It is away from the traditional Indian social norm. But then what happens is when that relationship breaks, the law creates a scenario where at times it is abused. So people have lived together for 4 or 5 years, and suddenly somebody says, well, when the relationship breaks up after a year, that this is a misrepresentation, it's a rape. It creates its own impediments. So again, I believe in a scene like this, there is a thought process to be looked into whether pre-marriage agreements as exist in countries abroad is something which should be given a recognition in the Indian context. Because if this is the kind of family relationships which are going to permeate, then there must be means to take care of the rights of both the parties, rather than jumping into criminal jurisdiction. With due respect, courtesy many lawyers who would create what I believe in every case, a bouquet of cases, I used to call. These are all bouquet of marriage, So one litigation gives into 5, 6 litigations at every stage of time. That's why settlements in marriage cases invariably results in settlement of anything from 5 to 10 cases which arise, because those are standard kind of cases which arise from them, and at times not even what the parties want. They want a resolution. A resolution is what? That people have not been able to get together, so part. Now, in that parting, there is a problem of monetary problem. So a fair solution. Yes, there are cases where both from male and female side, more from the lady's point of view, there's a feeling of being let down and that the life is going to be more difficult. So there is a resistance. But I've often found as a judge that if the parties are called to court and explained their point of view, that look, you get along with your life, you're going to lose some 5, 10 years of your life. What is the purpose of it? Reason does prevail in a very large number of cases. Now, in the same way, the object of cooling off period was what when we look to above? The object was not to perpetuate a purposeless marriage or prolong the agony, but give a party some time to have a thought process. But cases where the parties are already very clear that there is no chance of reconciliation, even albeit in smaller, shorter period of times, all endeavors of mediation have failed, and parties have mutually settled all differences to alimony, the time period would not be of great importance. Let me say, while coming in, I was discussing on the issue of mediation. I am personally a great votary of mediation, not only in family matters, but in all matters. I do believe that nowhere in the world is the court burdened with this volume of litigation which we face. Of course, a lot of the burden goes to the government because more than 50% cases are of the government or against the government. But personal disputes certainly can be resolved by mediation. Government will never settle in mediation, I believe. So that's a very tough task. But personal litigations, family litigations, matrimonial litigation, business litigations, all are something which are capable of being resolved, and people working in a collaborative exercise after that. I have a scenario in family matters. I remember a case where, giving an illustration, there was a complaint from the side of the wife's lawyer that, look, this man is like this, he's having other relationships and this. And the only thing the man's husband said was, lawyer said was, that, well, ask them, they said she is a survivor from a kidney transplant case, who gave a part of the kidney, part of the liver. She said, my husband gave a part of the liver after the problem was solved. I said, then he can't be such a bad guy after all, whatever his other problems. There must be solutions which come forth. How did you come to court? We both came together. So suddenly they said, well, when we are in one house, we just fight. Otherwise, we are fine. There is no problem. Children were grown up. And we worked out a solution. She said the husband is building some flats in the building. Let him give me one flat. I said, that's a very bad idea, because the moment you'll be together, you will be this thing. Let's persuade the husband to give a different nature of a different place of a flat. It did work out. It was a tough task working out that settlement, because on the lighter side, when I saw the lawyers to this two side, I knew I had a tough task ahead of me. This is one aspect as a judge I can say we see. Sometimes the two lawyers are one where we know they can work out a solution. And let me be frank, there are sometimes when we feel these lawyers will never let a solution get through. So then the task becomes more difficult, and the parties' involvement has to be more to find a solution. This built-in issue of, therefore I emphasize, the accumulation of assets, especially during marriage, is something which must be taken care of. And the fact that the wife is a homemaker doesn't make a difference, because she's contributing in her own way. But a distinction has also to be made between the acquired wealth and the wealth which is generated, because Western countries don't have this concept of devolution of so much of wealth as inheritance as in India. So some way that has to be balanced and kept separately if this has to work. But giving an adequate contribution to the wife for development of whatever the wealth is, even if the wife is a homemaker. Religious sensibilities and norms also present a problem in our country. Most Islamic practices remain uncodified. Practices like child marriage, halala, polygamy have no legislative prohibition through Shariat-based codified statutory law. And triple talaq was only struck down in 2017 by the Supreme Court in Shayar Bano's case, with Justice Nariman observing that since the practice permits the husbands to break the matrimonial ties as whims, the same is unconstitutional. A lot of development, I think, and judicial approach has changed over a period of time. What was thought to be hands-off approach has got into a hands-on approach in a lot of these issues. And I believe that's the correct view, though it is not a substitute for legislative changes. But issues of family law reforms does need to be approached as a policy, as one promoting harmony between religions and constitutionalism. In a way, no citizen is left disadvantaged on account of their religion. At the same time, every citizen's right to freedom of religion is equally protected. Now, this is a delicate balance, which in any reform of family law is more so. Another aspect that requires consultation and consideration is adoption, both single parents adoption and those by non-heterosexual couples. The non-traditional concept of family with a single mother, a single father, or a homosexual couple is still often looked down or frowned upon by certain sections of society. Individuals who are not part of the heterosexual, monogamous, and procreative marriage are not considered suitable candidates for parenting and face discrimination in various forms. As it is, I believe the adoption law, in my personal view, the approach needs to change. It is in a country like ours that a child takes 3 years for adoption. It's too much, I think, when there are children who need that care and their parents who are willing to do so. What is required is a change in perception of understanding of a family as a unit, and emphasize that familial relationships may take forms of domestic, unmarried partnerships, or queer relationships. Um, Unfortunately, the Supreme case created its own problems, actually, in terms of the majority view, I think, because it restricted from whatever the position, how it was being implemented earlier. Though as part of the minority, we had a different view, but then there is always time for a change of law as it arises, as we've seen this issue travel through the various years. Very interestingly, I became a judge in 2001. One of the initial matters sitting at the bench was the matter challenging 377. And I told my senior colleague it needs to be admitted. He didn't say anything, he admitted it. Then I said, let us put it for hearing. He said, you're being very ambitious now. There's a time for everything. And I look back at the history, and yes, there was a time for everything. It went through its own contours, but it did come up with some solutions over a period of time. The atypical manifestation of a family units are equally deserving not only of protection under law, but also the benefit available under social welfare legislations. The black letter of law must not be relied upon to disadvantage families which are different from the traditional ones. The same undoubtedly holds for women who take on the role of a motherhood in ways that may not find a place in the popular imagination. As I had opined in Supreme, our Constitution contemplates a holistic understanding of equality, which applies to all spheres of life. The practice of equality necessitates acceptance and protection of individual choices. This endeavor requires not only judicial interpretation of existing statutes, but also an attempt on part of the legislature to consolidate and make necessary amendments to law that remain archaic and rooted in a biased assignment of rights. In the end, let me say, often we have said that our culture is different, our placements are different. My own view of whatever limited understanding and I have read, our ancient civilization provided from some of the most broadest views of things which used to happen. If at all, sometimes we adopt what I think is the Victorian philosophy, classify it as ours, and then seek to justify the narrow-mindedness arising from a Victorian philosophy, which is not really where the history started from. Thank you very much.
Thank you very much, Justice Kaul, for setting the tone of for the evening. I think there's a lot that there is to unpack, both in terms of what you started with, that we do need an anti-discrimination statute, and what you ended with, that perhaps what we think of as our own is not our own at all. So I think there are large questions to ponder here, and we have 3 sub-themes to do that. The first sub-theme will focus on gender justice and women's equality. The second will focus on queer inclusivity, and the third will focus on on religious discrimination and minority rights. And we have a very tight schedule, so I'd request, as a matter of housekeeping, all participants on the panel to limit their opening remarks to 5 to 7 minutes. This will allow us a discussion both amongst ourselves and also with the audience, which is here in a sizable number. So without any further ado, I'd like to hand over to my colleague Rakshita to take us through the first sub-theme.
Thank you, Ardho. For this discussion, we'll be joined by Professor Bina Agarwal, Ms. Malavika Rajkotia, and Professor Saumya Saxena. As some of the things Justice Kaul said, when it comes to family law, the major fulcrum for reform very often has been gender justice and how equity can be achieved for women. And in fact, some major reforms that have happened in the area have happened around this, be it the passage of the Widow Remarriage Act back in the 19th century, or incremental reforms that have been made to succession laws over the years. Despite all of this, the conversation around gender equality remains alive and urgent in the third decade of the 21st century. And that is what we aim to do with the session two. We aim to dig a little deeper, and we aim to figure out how this aim of equity for women in various relationships and eras of family law can actually be achieved, and what reforms are needed, and how we can actually go about effectuating them. So to kickstart the discussion, Professor Saxena, I would like to ask you what your views are on the politics of personal reform and how you think that interacts with the aim of achieving equity for women. For example, how do the patriarchal forces of religion interplay with the issue of gender? And how has the Indian state in the past interacted with the issue of family law reforms? And what has the role of religion been in this?
So I didn't expect to be the first one to go, but I will. These are my opening remarks. I have about 5 to 7 minutes to answer your questions. Okay, so I will keep it as brief as possible. Thank you, firstly, the organizers of Vidhi for thinking of me for this panel. And there are 3 brief points that I will make, which I think address Rakshita's questions. So first of all, gender, like she said, is an entry point for a conversation on family law reform. It's hardly ever an end. So the conversation starts with how, oh, it's something that we're concerned about for women. That's how political parties pitch it. That's how individual organizations might pitch it. That's how individuals themselves litigating might pitch it. But the conversation will end up becoming about national integration, secularism, political party positions, and that's just how it is. And as a historian, this would be the first point I would make, because I can't work without a context, so I do have to contextualize this debate in what it will eventually become, which is that gender will remain an entry point. The second point that I will make, and I will give you examples of this, is that personal law reform has led to certain gradual incremental changes, and very often, if you do the long durée history of personal law reform in India, you will notice that the acts that are initially enacted or passed, they will end up taking a very different life. So I'll give you examples from the Special Marriages Act and the Muslim Women's Act of 1986 to show how actually these categories are not stationary but dynamic. And in every interaction between citizen and state, we layer on certain interpretations on these acts. So the Hindu Marriage Act, I would argue, looks very different now than it did in 1950s. The third point, which I will emphasize more on, is basically also coming from my position, which is actually a critique of a uniform civil code and my skepticism about it. And this is based on some of the practical examples of a uniform civil code that we've seen most recently in the case of Uttarakhand. And I also had a chance in like a front bencher. I actually read this model code which was circulated for us. So basically my engagement with that. So the first point that I wanted to make, which is about gender being the entry point of legislation, very often the tone of intervention becomes that we must save women from what personal law, what religion might hold. And this has historically posed very specific questions to women, where they are asked to choose between their community identity and their rights under this abstract entity of what uniformity might hold. And men are not having to make these choices, right? Because religious law in any case supposedly favors them. Now, very often what ends up happening, therefore, is that the original demand of the women's movement is not addressed in the subsequent legislation. We saw in the Triple Talaq case that women were concerned about the arbitrariness of the process. The 2019 law actually addresses the speed of the process, doesn't say anything about why it shouldn't be unilateral or why it shouldn't be arbitrary. So there is a huge sort of dissonance between original demand and the kind of legislation that you end up getting, which makes me skeptical of interventions in family law. The second point here is, also about the examples that I want to take. So let's start with the Special Marriage Act, for instance. So in 1950s, when this was being imagined, some of the Legislative Assembly debates were really about how this is an act to contain the rebels. So there are actual parliamentarians who are saying, this act is going to govern lipstick-wearing butterflies and not honorable girls of our households, right? So this is the kind of tonality that you saw in 1954 when the Special Marriage Act was being contemplated, and people said, they're going to give birth to children who are not going to be loved because these marriages will end in divorce, therefore have a simpler divorce process. Now, Special Marriage Act is actually an increasingly a very enabling piece of legislation, particularly for interreligious couples. Similar trajectory, I won't go too deep into it, but Muslim Women's Act of 1986 saw a lot of criticism because people thought it overturns the Shahbano judgment, which it actually doesn't. It actually gives you a different language. It kind of says that, oh, religion, constitution kind of say the same thing. And actually how that act ended up getting used is different from how people were seeking maintenance under Section 125. So actually middle class women started to prefer the Muslim Women's Protection of Rights on Divorce Act 86 because they said we don't have to prove destitution now. We can just claim maintenance based on what our lifestyle used to be. So the life of law cannot be determined by just that act that you produce. Citizens and interactions with state and subsequent, movements give it new meaning. Now I'll quickly move to my critique of the Uniform Civil Code, which has become even more pronounced once I saw the Uttarakhand draft, which is a 200-page document, but it in a lot of ways actually copies the Hindu Marriage Act. Large tracts of it are identical language if you go through that act. Now, the bit I want to focus on, in interest of the little time that I have remaining, is the bit that they say about live-in relationships. And this also ties into a little bit about the stable unions that I also read about in this code. But first on the Uttarakhand code. So the Uttarakhand code says that, there should be registration of live-in relationships. And my skepticism on this issue is because I think it increases state surveillance to the point that very often, let's say, heterosexual women are avoiding marriage because they're avoiding the trappings that come with marriage, which is that you don't want to deal with in-laws, you haven't made a decision on children, but having to register this live-in relationship attracts a very peculiar stigma to women, which will not affect men. So, for instance, how many live-in registrations can you have without the police actually tracking you and harassing you in some way, right? Will women not have a disproportionate amount of stigma if they've registered 2 or 3 relationships in the past? Will it not affect what the marriage market looks like for them in this day and age, and given what Indian context really is? So the argument that I'm really making here is that actually every time, let's say in a particular heterosexual marriage or a relationship, when women try to make the relationship legible to the state, what ends up happening is it erases and invisibilizes violence against them. Biggest example of this, marital rape exception, right? If you are a woman who's not married, the kind of law you attract for sexual assault is very different from when you're married. There's a lot more to prove that once you're married. Similarly, I mean, there are many such ideas, but, even in terms of domestic violence, the kind of fieldwork that I did, very often women would be told that if they were married, that this is a ghar ka masla, work it out in your homes. You don't really want to be running to police stations, court kacheris. And this is actually contemporary. So my fieldwork is from 2019, 2020, and this is still happening, right? So we all work with kind of different segments of society. And I worked with one where it was extremely common that if you were married and such assault happened, it would be more easily erased than otherwise. Having said that, I also think, and this is again continuing with point number 2, which is about how dynamic our thinking about legislation is, the marriage equality petition has done so much more than just, seeking marriage equality. It has actually forced us to rethink the patriarchal critique of marriage. Because so far, the kind of feminist scholarship that I'm indebted to when I grew up reading was about how marriage is a patriarchal institution. Now, same-sex marriage and marriage equality is allowing us to imagine a partnership, which is a marriage, which will not have the same gender stereotypes play out. So it's literally offering a different imagination. And here is when I'm also skeptical of giving it any status, be it stable union, be it, some sort of a contract other than marriage. If the demand is for marriage, it has to be granted marriage and nothing in between. Because I think that whenever state tries to codify what is a good, acceptable live-in relationship or a stable union, I mean, my first thought when I read the word stable union was that I thought all unions were volatile. What is really a stable union, right? And if you're married and you're in a, volatile union, you're protected because the state can't come in and say that we'll determine your stability, or the state doesn't have the right to tell you that, this would make it stable. Or for instance, the man can't say, no, it was actually a casual union. So what are the conditions that you will put in place in order for a relationship to qualify as stable or marriage or wherever? And do we want the state to intervene to that extent that it determines every degree of our relationship, right? And which is why I think the marriage equality petitions have already offered us this great plank to actually rethink what patriarchal marriage might look like, and what patriarchal marriage might look like, an alternate to a patriarchal marriage might look like, and which is why there is no in between for me. If the demand is for marriage, it has to be recognized for all citizens. So I'll conclude with simply saying that just the practical aspect of it, because as a historian and as someone who's worked with legislative drafting, as much as I loved this code, given the political context in which we operate and the actual sample of the code being the Uttarakhand code, I think that sometimes it becomes a very uphill battle for us to fight these as a unified code which would include everything. It becomes easier for us to say that, keep your religion, we'll include marriage equality under the SMA, under the Special Marriage Act. We can say that, look, we don't want to deal with, Hindu matrimonial property at the moment. We want to deal with Muslim succession, and we do that separately. So for me, personal law codification that works separately, in my experience, gets much greater compliance from communities than an idea of a unified code, because then you have to convince everyone. Whereas women don't have to make that choice if you codify personal law separately. So in interest of time, I think I'll stop here.
Thank you so much, Professor Saxena. That was very insightful, and there were some really good points, which I will come back to later. But just to move on to Ms. Rajkotia, and this very neatly flows from what Professor Saxena said. But when it comes to intimate relationships, be it in the form of marriage or be it in the form of what we call live-in relationships, how do you think inequalities within such relationships can be addressed? Be it in the form of violence, like Professor Saxena also pointed out, or be it economic inequalities, which do persist very often. And how do you think, what kind of reform do you think is needed when it comes to things like, say, division of matrimonial property, or to the maintenance regime, or even to custody regimes, to actually ensure equity for women? And another thing that you have written about in the past, in fact, is that when it comes to women's labor, it is often unpaid and it is often invisible. What are some of the ways in which such systems can be designed that women's invisible labor is adequately accounted for?
Right. Thank you. So in family law and in our system as a common law country, we do have this marvelous margin, which is equity and discretion, which works for and also against, because very often judges use equity more from the context of their personal morality and views rather than any particular defined context. And that is, but that the plus side is that it gives them enough latitude to around the statute to try and get as close as possible to an ideal just resolution. And even though Justice Kaul said, with due respect to lawyers, but we all know what that the prefix is. But the truth is about the bouquet of cases that Justice Kaul has sort of has mentioned as not being entirely happy with. But the truth of the matter is that we as lawyers do not intend when we start out. I am one of those who like to settle, and I don't disagree that there are many who don't. But having said which, nobody starts out, and certainly the client doesn't start out by saying file every case, because it obviously means a whole lot of expense apart from anything else. Now, but why is that bouquet needed? Because there is no one statute that actually takes care of all the reliefs. So for a woman, for example, if I need immediately overnight a protection order, I have to go to the magistrate's court. However, then the husband will move the family court for divorce maybe. Then there will be a petition with regard to children, because even though the Hindu Marriage Act and the Special Marriage Act do have separate sections on child, orders for children, but the party might want that to remove the other party from being a guardian, because the default position is that they are joint guardians, but that too is a default position that we are inferring after Gita Hariharan. But truth be told, under the Guardians and Wards Act and the way the law is, it is the father who's the guardian. We'd like to pretend that the mother is as much a guardian, and judges say so. But the Supreme Court during Geeta Hariharan fell short of actually striking down that particular provision as being unequal and said, yes, the mother will be a guardian in the absence of the father. Now, that means nothing. Does absence mean death? Does absence mean distance? Because if it's death, the statute in any case says that the mother will be the guardian. So, but what about a father who's fiercely present and obstructive, not permitting something as simple as a school application? Now, those are things that we can't do in a Hindu Marriage Act, so we are constrained to go under the Guardians and Wards Act, and then spend lot of hours rereading Geeta Hariharan to say judges actually meant that, I can. So we go, there are one judgment by Justice Manmohan Sareen saying the primary caregiver can make certain day-to-day decisions, but this is hence the bouquet. And sometimes, now there are two issues in a marriage, primarily, never mind fault, never mind irretrievable breakdown, never mind any of that, or the stigma. By and large, all of us sitting in this room are coming from a elite privileged class. So the social context is completely different. But when we are developing law and talking about it, it's not just for ourselves. It's for a lot of people who are not able to be in this room for a host of reasons. Now, in that context, law has to be developed in a court. And I have no problem with mediation. It is indeed very good. And I, as a matter of practice, file for what is called pre-litigation mediation even before going to court, hoping that it will settle. But when it doesn't, and we do go to court, we also have the opportunity to develop important precedents which are necessary for the development of law for the country at large. These precedents are needed. Now, here we come to many, when we were talking about maintenance, which is the main, so that's with regard to fault or not fault. But the two real issues are children and property. The children, invariably, the husband seeks to assert control over for two reasons, and love is not primary amongst them, is my experience. It is to assert power over the woman, and often to intimidate her and distance her to giving up substantial alimony just so that she says, leave the child alone, I don't want anything from you. Now, if that happens in a mediation because she's intimidated by a custody battle, it is not a closure with a sense of justice, but it's a compromise. Mediation is a compromise, I agree. But at the end of it, when you're through a legal process, you should surely be closing with a sense of justice so that you can move on with your life. It's all very well to say, move on, don't look back, and so on. But eventually, the person who's actually walking that path is quite alone in dealing with it. Then comes the issue of, yes, there are judgments like Naveen Kohli, etc., which say that irretrievable. One very important line said in Samar Ghosh by Justice Dalbir Bhandari was, irrational refusal of divorce is also cruelty. And I so agree with that. But notwithstanding these time-to-time judgments that come out depending on the particular view of that bench, we even have a judgment like Devinder versus Meena after Naveen Kohli, which says that the woman should not, it is cruelty for a woman to ask to live away from her parents, parents-in-law. It is cruel for her to refuse to cook for them. Now, I move to one of the most important problems that we have, which is framing women in stereotypes. So, and judging them as invariably falling short. So in all of this bitterness, I come back to why we need to file the bouquet of cases. We have separate courts for separate maintenance laws. There's 125, there's the Domestic Violence Act, there's the main statute. Now, when each date of hearing is in each court is 4 months after, then sometimes one just wants to take a chance and file in other courts, hopefully that we'll something will strike and we'll get somewhere with something. Now, how that is to be addressed is an administrative problem. Perhaps there should now some courts in Delhi, and I want to say Delhi is heaven for lawyers and the way it works, because I have worked in high courts all over the country and in family laws, and it is soul shattering, may I say, and I end up feeling sorry for my clients. I feel quite sorry for them in any case for being in the system, because it's not the best thing. But having said which, more sorry when they're not in Delhi. Now, having said which, the framing of stereotype now that I flows even within Delhi. As we speak, I'm doing two highly contentious matters where my client, and this is where your argument with regard to several live-in relationships and how will she be judged. My client is being called a gold digger in court by the other side lawyer, and the fact that she is not worthy because this is her third marriage. She is judged as a mother because she doesn't have custody of the previous two children. Of the two children from the previous marriage, that she let go because she thought that the father would actually look after them better. She had settled. It was eventually a divorce by mutual consent that she settled and gave up custody for this reason. And today it's come to haunt her to say she abandoned them. She has not accessed those children because the father, after the settlement, has just refused to allow her access. So these are, I don't have solutions. I'm just telling you the journey, and that it is very easy to criticize the legal system. But what I see every day is everybody, including judges, and I have seen Justice Kaul sitting in the Supreme Court, actually finding time to be in chambers and talk to parties. But everybody is not like that. So yes, when Justice Kaul says it is my vision, it's progressive, but there are many who are not. When we mention Section 497, which now we know recently, Justice Pardiwala says, why is Section 497 there? It is being misused. Now, if there is a weapon in a woman's arsenal to fight her battle, there's no reason why she won't use it, number one. Number two, nowadays, when tax authorities are misused and ED is misused, nobody is thinking of abolishing those departments, right? But yet the misuse, when it's done by a woman, is such, and it is perceived as misuse. So she ends up constantly being on the defensive to say, I do not have malice. I am a good mother. I don't mean to be bad. Whereas the question should really be, what is the issue? And the issue is, as Justice Kaul says, fair division of at least what is earned in the marriage, and recognizing the woman's labor, which is so far rendered invisible. There is a recent Madras judgment which has recognized the woman's labor, in the sense that the husband was living in Saudi Arabia and sending back money. She was looking after the children. He bought a house. He bought it in his name from the Saudi Arabia money. And this judgment is progressive because it's not limited by a narrow reading of the statute. It's not saying, oh, but she can't have title to the property, she only has rights in it. What it is saying is, I find that she can have claim title to the property because it is bought in his name, but he would be holding it in trust for her earnings as well. So it is an extremely landmark and progressive judgment. And it is these such judgments that are the stepping stone and every brick that builds the edifice of a more progressive legal system.
Thank you very much, Ms. Rajkotia. Those were very insightful points, especially from a practitioner's perspective. I will now move on to Professor Agarwal. And Professor Agarwal, you have written in the past how when it comes to actually achieving independence and autonomy for women, ownership of property remains a very, very important factor. So considering that, how do you think the inheritance law regimes in India currently fare on that account? And secondly, we know that merely granting inheritance and property rights may not be enough. as Justice Kaul also said in his address. So how do you think, what sort of reforms are needed to actually effectuate change on the ground in the face of especially parental resistance to giving such property?
I could just go there. That's okay. So thank you, Vidhi, for inviting me in a room full of lawyers. I'm an economist, possibly the only one, but I'm self-taught in law, and I did play a role in the amendment of the 2005 Hindu Succession Act. So I'll basically make 4 points. First is the issue of inheritance laws. Are they gender equal? And of course, the answer is yes and no. So we are still governed by personal law, as we all know, and these vary by religion, but also by region. Region comes in because agricultural land, the laws relating to agricultural land have varied. Now, we know that for Hindu women governed today by the Hindu Succession Amendment Act 2005, the laws are pretty much gender equal. And the same is true for Christian and Parsi women. But the inequalities that persist are especially for Muslim women and tribal communities. Now, we know that taking into account Poonam's thing about dynamism, but nevertheless, Muslim women are still governed by the 1937 Shariat Application Act. And here we face 2 types of gender inequalities. Firstly, there's a generic issue of the Shariat where women's share is half of that of men. And the second is that the act does not apply to agricultural land, because there's a discriminatory clause that agricultural land succession will devolve according to the tenurial laws, land reform laws of every state. And if you look at the northwestern states, 6 of the northwestern states, the land reform laws specify an order of inheritance which goes back to the 12th century Mitaksha law. Now, this discriminatory clause was removed when the HSAA was amended, but it hasn't been removed for Muslim women under the Shariat Act. Now, tribal women, especially as we know in Northeast India and East India, are still governed by customary law. And there's a sort of romanticism about custom must be giving women more rights, but actually having looked at all the customary laws across a wide range of ethnic communities, you find that they are all gender unequal, except if you take Meghalaya, where you have large pockets of 85% are matrilineal. And so when these laws are codified, clearly the question arises, is it an local identity, or is it the issue of women which was raised? And I think here there is an opportunity to actually codify laws which are gender equal. So legally, we still have a long way to go for making inheritance laws gender equal. And I believe this cannot be done within the framework of personal laws. The underlying vision has to be constitutional equality as the basis for law. Although in practical terms, I agree that the best way to move forward, as we've done so far, is to first amend each personal law. But when you take Muslim women, then I don't think there is a point beyond which you can go within the personal law ambit. Second, despite legal reform, there are huge inequalities in practice. So suppose we take agricultural land, which is the most important form of property in India. A few years ago, after much effort, I was able to locate data to answer a simple question: how many and which women own land in India? Now, this data covered 5 years from 2010 to 2014 for 9 states. And my analysis provided 2 surprising findings. First, I found that in 2014, which is 9 years after the HSAA 2005 was passed, women constituted only 14% of the landowners and owned only 11% of the land in rural landowning households across 9 states on average. Second, the majority of the women who received land received it as widows from husbands and not as daughters from fathers. Now, this is the most surprising and striking aspect of these results is that while legal reform has consistently moved to enhance the daughters' rights since 1956, when the HSA was passed, ground practice continues to favor widows,
whose rights have always superseded that of daughters from the 12th century Mitaksha, because there you have the widow, after four generations of men, you had the widow, the unmarried daughter, and the married daughter. In other words, legal reform has been trumped by social norms, and these are significant. And we need to then ask the question, how do we change it? I don't have the time to do it now, but although I have some thoughts in Q&A. The third point is that when we talk of gender justice, we club all women together. Even feminist scholars and activists do not differentiate between different categories of women. So for instance, if we take the 2005 Hindu Succession Act amendment, it made all daughters co-partnery in joint family property. Now this increased their share in joint property, both because then they got a direct share in the joint family property, and they have an equal share in the father's notional share of the co-partnery. However, the reform reduced their father's co-partnery share the moment the daughters enter into it. So the total amount decreased and the widowed mother's amount decreases. So although the 2005 amendment is a big step forward, you can say, for gender equality, it has created serious inequalities among women between daughters and mothers. And I think we need to be mindful of this because this point is actually not recognized. When we talk about, I'll deviate a little bit. When we talk about divorce, and you say after 3 years or 2 years, the woman says, I'm going to now leave. And fairly, if she's been beaten up, she needs to leave. We think she should get half the property acquired after marriage. But what about in our extended families when daughters and mothers are also doing unpaid labor in the house, and probably more, rather than the 3 years or 2 years that the wife has spent there? But I find there's a lot of writing by feminist scholars talking about community of property without recognizing the rights of other women. My final point is that both legal and social science scholars need to track the delivery of gender justice on the ground beyond legal reform. So in a recent paper, my co-author and I, we looked at all resolved high court cases filed by women co-partners or against them from 2005, when the HSAA was passed, to 2020, over 15 years, across the country, across regions. And we examined who opposed the women, what kind of property was disputed, regional variations, time taken, case outcomes, and language of judgments. So I believe this is the first paper of its kind to do this. And we found that 76% of the 505 cases, not a large number of cases, which were resolved, women received some property. So you'll say, aha, well, that's a great positive outcome. But wait, you need to ask, what kind of property did they get? In most cases, they got only a share of their father's co-partnery property, to which they had a claim, even in the 1956 Hindu Succession Act. Most did not get their direct share in co-partnery property, to which they had been entitled by 2005. In other words, judges can fail to actually rule according to the intent of the law, which should be a principle in itself, either because of male bias, or some people say they're just too busy. And these are things which judges can answer. So I'll just end with summarizing my 5 points, 4 plus 1. First, we need to have a distance. We still have a distance to go in the amendment of the inheritance law, whether we do it within the ambit of each personal law for a start, or we go the direction of uniformity, of which I agree. There are serious problems. I've written a lot on that. Secondly, even if the law is gender equal, few women own property in practice. Third, women who do inherit are typically widows, not daughters. So it is too late in their life cycles to get the full benefits of ownership, on which economists and other feminists have written hugely on what those positives could be if they actually had immovable property, including security from domestic violence. Fourth, both scholars and reformers need to pay more attention to the unequal, potentially unequal results on different categories of women. And then many judges, of course, we know, continue to be gender biased in their rulings. We did look in the paper, are women judges any different? But the sample was too small because rather few women, women become judges. But that is by no means is it necessary that simply because of a woman, your language will be very different. By the way, the Delhi High Court resolutions were among the most conservative. So we might rethink that living in Delhi is the best thing that could happen to a woman.
Thank you for that, Professor Agarwal. Even though we have a lot of questions, and I think some very interesting themes were touched upon here, in the interest of time, we will move on to the next theme, which is queer inclusivity. And in the end, we'll circle back to some of the questions that we have here. So I'll just hand it over to my colleague Kartavi now.
Thank you, Rakshita.
Sure, I can actually address, definitely. I think one of the things that emerged over here right now is how different categories of women and how their rights can be balanced against each other. And I think this was a common theme between what Ms. Rajkotia said and what Professor Agarwal said. What I would like to invite you both to comment upon is that, for example, how is it that property, because there is a limited amount of property that every family owns, how can this property in a way be apportioned so that the requirements and rights of different categories of women are taken care of? For example, when it comes to matrimonial property, how can it perhaps equitably be divided to ensure that while the wife's rights in such a scenario are taken care of, like Professor Agarwal pointed out, somehow the mother and the daughter in the family who have also contributed their unpaid labor, their rights are not relegated to the second position. And to Professor Agarwal, my question here would be that how do you think inheritance regimes themselves can be operationalized so that, for example, daughters and even wives end up getting their rights more often, daughters and sisters end up getting their rights more often, and it's not just through the widowhood route that you end up acquiring that property, which is what we often end up seeing on the ground. Professor
So I,
Ms. Rajkotia.
what to me, sorry, what was the question to me?
I was talking of division
No,
of
so
property.
community property,
Yes.
that's right. I think the concept of community property, like in the West, it's a Western concept, of course, but it needs to be introduced, obviously, in the circumstances of each case. But broadly, it is more to do with a nuclear family. I have basically whether, he's traveling, he's abroad, banker, chartered accountant, lawyer, whatever, businessman, and the woman looking after the house, the children, however educated she might have been, not allowed to make a career because of, even though very progressive on the face of it in terms of careers, etc., but extremely conservative on how a woman should be, is in fact what I've noticed. But your second, which you've asked, Professor Agarwal, and I would like to follow that up really, because it's something that I have seen in maintenance cases, for example, judges sometimes saying that because you come from a wealthy family and that you now, by virtue of the 2005 amendment, are a co-partner there, and she doesn't have access to that in any case, you are therefore not entitled to maintenance from your husband. You see? So it sometimes operates against her. And she ends up isolating from both families, because when she goes back or claims money from them based on co-partnery, it is, she alienates them, but the brother, the father very often, and so on. The husband, in any case, she's unhappy with, so she's had to leave. Then comes another thing where domestic violence, yes, if she is economically powerful, instances of domestic violence should be less. But in my practice, I have not seen that. And because the social construct is still that she very rarely actually has control over the money, which she should be having. In fact, dowry was also supposed to be for her alone, her stridhan. And today, police, we have to file 498, etc., to recover stridhan. which up till the 93 judgment of Pratibha Rani, they were, she didn't even have. That is the judgment which brought in that, okay, 406 can come in, 83, sorry, that we can use it as for criminal breach of trust. So that was with regard to 2005, one aspect. The other is the retrospectivity into apps right till 56 has created its own set of problems.
Thank you.
Okay, so let me, you don't need to repeat anything. Let me pick up a couple of points. One is, let's start with the issue of domestic violence. Now, I've always made a distinction between movable and immovable property. So it's absolutely correct that when you give women dowry, and most dowry, except in very rare cases in South India, is not in the form of land, except Kerala and parts of Karnataka. Otherwise, it's in the form of movables. And that's the family calls upon that. If bhabhi mein bhai ki shadi ho rahi hai, ya the in-laws take it, or there's a drought in the family, the link between reduced risk of domestic violence and women owning property relates to immovable property, which is land and house. And this was a seminal paper that a colleague and I did. We looked at 500 randomly selected rural and urban households in Kerala, that woman-friendly state. And we found that women who owned neither land nor house, the incidence of violence, domestic physical violence, was 49%. Those who owned both, it was 7%. And in between was 10% if they owned a house, 17% if they owned only land. Then we controlled, as economists do, for every other thing, which is education, employment, substance abuse, et cetera, et cetera. And we found this was the most important factor. So it's a huge protection if you own immovable property. Why is it a protection? Because, for instance, if the woman says, if you beat me up next time, I'll leave, and she has nowhere to go, maybe for a few days to a friend or her mother, it's not a credible threat. But if she has somewhere to go, it is a credible threat. And that is what acts as a deterrent. And this is pretty robust in terms of. So one of the unfortunate things that we have not done is connect the empowerment that was obtained from the Hindu Succession Amendment Act 2005 and link it with the Domestic Violence Act. To say that the woman, the HSAA 2005 enables you legally to return to your parental home as a legal right, and not as courtesy, the brother and so on. And of course, we know that she could act as a karta and so on. A lot of women don't do that. The second issue is a very complicated question, which is that 11% of agricultural land is owned by women, but the law is equal. And that's not something that can be easily answered because, all of you, I could ask this question of all the men sitting here. Are you willing to allow your sisters to have an equal claim? You may say yes here. You may say you feel differently later. Nobody wants to leave property. Let's be fair. Two brothers can kill each other over property. So property creates huge amounts of conflict, and we shouldn't gender it by simply saying if women ask for it, it leads to conflict. I do want to say one small thing. We need to think of property differently. So suppose you take land. One of the arguments that I faced when in 1994 I was writing A Field of One's Own was that it will lead to fragmentation. But the point is, when men migrate to cities, their rights are still preserved. And basically, a lot of times people cultivate together. Fragmentation is a problem on agricultural productivity if you actually split up the production and not the ownership. So if all of us were part of an extended family, we could all own a few cents of land. But if, let's say, Justice Kaul decided that he would do the farming, he could give us a share of the harvest. So and the second way to think about it is we really need to ask, can women actually buy property jointly? So for instance, on domestic violence, instead of, let's say, dowry, suppose parents said, well, I'll give you a key to a small apartment if it's upper middle class, or 6 women get together and say, we're going to buy an apartment with 6 rooms, a common space, and that will be our exit option. So I'm merely saying, let's put it out there and think about property in a different way and not always in tiny amounts as individual property.
Thank you so.
Add one thing. One of the small measures which has worked is also the differential in stamp duty I've seen in cities. So a 2% differential in stamp duty means that if the husband and wife or the man and the woman get a registry done together, they save on stamp duty. Now, just thinking aloud, it can be maybe larger differential in real estate registration. If you say, okay, if it's 6% plus 1% for a man, and it is 5 plus 1, you make it okay. The women will be half of what a man's stamp duty is. It's a monetary incentive. So the man also feels more inclined if there is a monetary incentive to jointly holding property.
Just add one more thing, because many of you are making law and policy, is that the government has a role to play. So for instance, in the 11th five-year plan, I was part of a working group, and we made one small recommendation that every single household in rural India, which is where they don't own homestead, if they're landless, 10 cents should be given in the woman's name. Now, it was a one-line recommendation. It has been implemented. Not 10 cents, maybe 5 cents, maybe 3 cents, maybe it's joint property. But I'm saying sometimes very simple policy shifts, which weave into policies relating to anti-poverty and other things, can actually help you to even slightly level the playing field.
Agarwal, this has been a really insightful session. And I think what has emerged is that when it comes to actually achieving economic security of women, there's a really complex web of laws that works together, be it inheritance, be it property rights regimes, maintenance regimes, and like Justice Kaul pointed out, even things like how much stamp duty is levied. And that all of these rules need to be thought about long and hard, so that we can actually come to a place where women are able to achieve that kind of economic independence. We'll move on to the next session now on queer inclusivity, and I'll hand over to my colleague Kartavi for that.
Thank you, Rakshita. That segues beautifully into our next sub-theme, which is on queer inclusion in family laws. Any conversation around gender cannot be de-linked at all from a conversation around inclusion of different kinds of identities, especially queer identities. We have Dr. Sourav Mandal, Dr. Madhavi Menon, and Mr. Anish Gawande joining us for this conversation. Dr. Mandal, in your experience, in considering your work in the space, how do you think we can make space for queer identities and various forms of evolving family structures within the law, especially family laws or laws that revolve around personal relationships?
Yeah, hi. Thank you for the question, and thanks for having me. I think so. I think firstly, there's a question involved over here, like queer inclusion. So, what do we mean by queer? And I think that in itself is a very fluid understanding, I think, and it's very loosely used in our courtroom litigation now, which is in a way a good thing, at least in terms of at least the word is now there on the face of it, right? It's there on the court record. It's now there in the, I think it's roaming everywhere. So queer. I mean, so how does Vidhi's excellent effort towards having a consolidated uniform family code, I think it's very inclusive in so many ways. And I think that involves a lot of queer um, lives at the same time, if not all, and that is not possible, certainly not possible with the sort of the frontiers of queer imagination, or what queer theorists or a radical queer imagination would be, is to sort of give recognition to polyamorous or all kinds of non-dyadic relationships, non-monogamous relationships. That's not going to happen very easily in the given political circumstances where we operate, right? So first thing is to sort of then understand that, okay, queer inclusion is in itself that has to be understood in a context, right? And the context comes from the socio-political landscape where it is operating. So now, given where we are in India in these times, I think it's a great effort, first of all. We can always have discussions, and it's great to have discussions. And I'm glad that this forum is sort of engaging on a lot of those issues. What is a stable union? I think Professor Saxena said, like, why is it stable union? And I think that in itself is a great area, sort of. So stability and queer doesn't go. I mean, Professor Menon is here, so I don't need to say anything, I think. So stability is okay, great, but it's not always what, a queer imagination would be or would like to be, it's not to be defined. The idea of a queer is sort of to sort of stay away from being defined and being sort of, and the moment you say you are stable now, you are in a stable relationship, then it's not queer inclusion, I mean, in that sense. But nonetheless, it is a LGBTI plus inclusion for sure, right? And again, as I said, queer is a very, so I will make 3 points. I will not take much time. I'll just make 3 points. It's a slightly radical imagination of what family code ought to be. And again, I totally understand that that's not going to happen, at least probably in the coming decades. And, but then there are, we should always, I mean, I never thought in my life, I think when I started my career as a student, as a law student, that there will come a moment when we will have a superior type of moment or a NAS kind of moment. And I think as Justice Kaul said, there is a time for everything. Perhaps, let's see, you never know. I think changes happen quite, and the way Vidhi is making efforts and many civil society organizations are making efforts, I think we don't know what's going to happen. So let's see, one can only be hopeful. I think first point I will make is that there's that law has an ideology, and I think we need to recognize that. And I think this code is very clearly recognizing it and very strategically dealing with the problems in law's understanding, right? So first thing is to recognize where is a problem. So law has its normative framework is patriarchal, it's cisgendered, it's heteronormative. And I think it's very important to sort of deal with it, but yet in a very strategic way to sort of then present it in a manner that, I think Professor Saxena's suggestion really makes a lot of, I think in my mind, at least it resonates a lot, that instead of having a full-blown omnibus kind of a big code, a comprehensive code type reform, maybe small personal laws could be reformed like one by one, or at least codified. Like, this codification of personal laws might involve a little lesser conflict in terms of the intercommunal, So, but anyway, I think we're headed towards this, I suppose, at very soon down the line. I think like Uttarakhand, they will be probably in 2024 or 25. By 2029, I think we might end up having something like this, or God knows. So if that happens, then of course, I think these conversations are very important. So the first thing is to recognize the ideological problems in the law, the normative problems in the normative framework in the law, which means that it's not just family law. And Kartavi asked that, how do you see queer inclusion in family law? Look, family law doesn't operate in a vacuum. It is in the middle of a galaxy of other laws, right? So it operates with criminal law. As you can see, domestic violence comes up. You can see the tax laws come up, criminal laws come up. So Suprio, in that sense, the judgment at Justice Call, I think I must really congratulate at least Chief Justice, and you, both of you have made an effort to sort of, I think recognize the problems. And of course, the other side also has done, I think, the way they should have probably done. But anyway, I think in my mind, I think the second point that I'll make is that if in like the Vidhi code, I think marriage is one thing, and marriage must become sort of much more. I think the reforms in marriage laws are sort of in a way put in over here, like dealing with irretrievable breakdown of marriage, conjugal rights, for example, all those kind of problems are dealt well. Stable unions, it's a great option to register these stable unions, which the code also does. I think one of the great things that the code does is that it also recognizes de facto relationships. And I think that way you don't have to register, or you don't need to register if you cannot register for whatever reasons, right? And I think that's a great way to sort of allow inclusivity, as Professor Saxena was pointing out, that there's a stigma attached to registration. So I think that way, my second point is that marriage is one entry point to have a family. If you cannot marry or don't want to marry, it's a registered union, which the Uttarakhand code kind of very conservatively does. Many of us have a problem. And I think the Vidhi code is making it easy and more inclusive, because the Vidhi code is also making another third entry point other than registered unions. The third entry point is a de facto relationship. So if you haven't had a registration moment, but you think now you're in a trouble, you go to the court. Now you want it to be recognizing your relationship, and that's a great way. We do it in Scotland, we do it in the Australia, and I think that's a great way to move on, and our courts always have the equity, the power of Article 142, as Justice Kaul has said, and that speaks a lot. So I think that's a second point on a normative level. The third point is that a robust legal reform is what a queer imagination would like to have, but then that's not going to happen, perhaps the way, because then you will end up dismantling so many things. You don't want that. So, so I would say that then we need at least a gender neutral interpretation of of sexual offenses, at least, right? I think that is a great way to look at how violence is not just the stereotyping of women would, I think, then stop to some extent, or at least might change. I mean, of course, legal reform and social reform are two different things. But yeah, so gender neutral approach to domestic violence, sexual violence, to other similar sexual harassment, for example, at workplace, all these things I think might be a good starting point where we are certainly not. Although Domestic Violence, Sexual Harassment Act are great efforts, but then it further reinforces the notion, bichari, the aurat is the bichari, right? She's the one, the victim, right? The male is always portrayed as the bad guy, which is not the case, right? And same-sex sexual violence is just not there at all in all these laws. Intimate partner violence within same-sex families, same-sex intimate relationships is just not considered in the imagination of the normative law where we are. So I think that needs an overhaul, but then it's a long way, and we understand that. Marital status as a ground of anti-discrimination is a great, I think, effort. And I think Justice Kaul was talking about how to reimagine anti-discrimination laws. And I think there we need a lot of reform. And I think superior judgment. And I think all the judgments in the last at least 5-10 years since NAS Foundation happened, I think in Delhi High Court, a lot of things have changed a lot in a very positive spirit in that sense. I mean, at least NALSA had opened the door to sort of have more grounds into the existing grounds of Article 15. So sex now includes sexual orientation, gender identity. That's a great start. Robust judicial, I think, a very good, I think, example would be, again, what Justice Kaul was saying, and I think Advocate Malavika Rajkotia was making the point that, judges, it depends a lot on the judges and lawyers, and it is actually. So I think if the judges start at the Supreme Court, High Courts, I think, to sort of lead the way towards a more inclusive, free of stereotypes sort of a way, I think it will take it will sort of take us quite a long way, I think. So I'll just stop at that. And yeah, we can always take questions. Yeah.
Thank you, Dr. Mandal. That's a great fulcrum to start the conversation. My next question is to Dr. Madhavi Menon. With the marriage equality case and the hearings, one thing that has been brought to the fore is the inherent tension. There is a certain tension between the politics of the queer movement, the demands of the queer movement, and the ability or the need of the law as an instrument to bring about inclusion of those demands or bring about any sort of change. So do you have thoughts to share on that?
Thank you for the question. Thank you to Vidhi, first of all, for inviting me and for this amazing model code, which really is a model code. And thanks to Namrata for being just such an indefatigable organizer and moving spirit. I'm actually the wrong person to be on this panel because I am not at all a supporter of what we call queer inclusivity. And I am not, in fact, a fan of the law either. I am a fan of the law in as much as I find it fascinating, but I find it absolutely bizarre that anyone, and this is to go back to what Professor Saxena said, I think wonderfully early on, I can't imagine how anyone or why anyone would want their desires to be governed by the law. And so I do want to talk about, and I will talk about the Superior case and same-sex marriage, which I am not a supporter of, and I'll talk about why. But here we are talking about family law. And since I'm not a lawyer, I'll talk about family. And I want to talk about this in relation to what I call two divorces. The first divorce is of something that should never have happened. And the second divorce is of something that really badly needs to happen. The first thing that I'm talking about, and I'm talking about a divorce that should never have happened, and I want to talk about it by borrowing Janet Halley's wonderful phrase, which she calls family law exclusivity. And family law exceptionalism, it's FLE. And what she means by that is the idea that family law is a sphere of law that is completely separate from all other kinds of law. And this family law exceptionalism, family law exclusivity, she traces historically as a phenomenon that arose around the world in the end of the 19th century. And of course, we in India, I hope, do not need to be reminded about what was happening around the world at the end of the 19th century. What was happening was, of course, a colonial codification of laws, which continue to haunt us today, despite the not so good efforts of our judges and lawyers, right? So there is a way in which the end of the 19th century brings into being an arena called family law, which is culled out and carved out of what the Germans then called corporate law. So there is an absolute distinction between the family and the marketplace. This is also, you notice, not just the rise of colonialism, but parallelly the rise of capitalism, right? And these phenomena are very, very closely conjoined. And the minute you separate family law from corporate law, what you are doing in effect is something we continue to struggle with, which is you say the family law is domestic, is private. That's another word that judges love and that I absolutely can't stand is privacy, but we can talk about that later. The notion that family law is private, is personal, is domesticated, is touchy-feely, loving, supportive, is very, very clearly the sphere of the feminine. Right? Another word I don't like, homemaker, right? This is another one in which the women are supposed to belong to the private sphere, the sphere of family law. By definition, the sphere of the corporate, the marketplace, the cutthroat, ruthless money-making enterprise is the domain of the masculine, is the domain of the man. So the minute we have family law carved out of and as opposed to corporate law, we also have a deeply gendered distinction, which also falls along the lines of the private and the public. The family law, women are supposed to be private. Corporate law, men are supposed to be public. And so this explains so many of the percentages that Professor Agarwal, for instance, brought up as well. Right? So this is the kind of divorce that happened towards the end of the 19th century, and that I strongly think we need to undo if we are to think of family law not as a separate or separable realm, but as a realm that is very, very deeply described as being private in a public way, which is to say, it is a public determination of what is private. There is nothing private about the private. It is always public. And the artificial distinction and division of the world into the hemispheres of private and public only serves the cause and the ambitions of the public sector or the public sphere. And we already know who occupies that public sphere. So that's the first thing I want to talk about, which is the divorce that should never have happened between family law and corporate law or public law, that these two things need to be thought together because the family too, as we all know, is an economic unit. And that we need to think about money matters. We need to think about inheritance. Professor Mandal already talked about, the multiple laws that affect family law, and we cannot carve it out as a sphere of something that's private or personal. By the way, this issue of personal laws, right? All these terms that we're taking for granted also has a history. Personal laws were very much introduced by the 1864 Law Commission run by the British colonizers. So when we talk about personal law, please let us be aware that this is not a trans-historical universal. It is a very clearly politically targeted movement that we must actually resist rather than take on board as though it is this universal truth. The second divorce that I want to talk about, which is something I referred to earlier, which is a divorce that should have happened a long, long time ago, which is the divorce between marriage and rights. The reason I was not a supporter of the same-sex marriage petition, the reason I did not think it was particularly enlightened in any way, other than the Rituparna Bora sort of petition, which we can talk about later. But the reason I did not think it was entitled in any way is because all it wanted was to continue a situation in which the state gets to decide that what right you will or will not get depending on who you have sex with. And we are all happy for the state to do that. I mean, I am shocked by how many people are in support of expanding the franchise of marriage. We need to have a concerted effort to say there is no relationship between marriage and rights. Every one of us should have the same rights, as long as you're citizens of the country or whatever that political legal system is. But who I have sex with should not allow the state to determine what kind of rights I do or do not get. And so again, this becomes a question of challenging the assumptions on which law is based. Rather than saying, oh, here's the law, let me try and make it a little more inclusive, when the institution of marriage from its fundamental assumption is not inclusive. It is a violent institution, and it is an institution that always has violence directed against women, has violence directed against anybody who is supposed to be the weaker or more vulnerable partner. So to say we want marriage for more is actually not to challenge the violence of marriage at all. And in fact, I wish we were able to, all of us, come together and put together a petition that said, please divorce marriage from rights, because we all need rights, but maybe we don't want all want marriage, right? And certainly those who want to have to get married, go for it, right? Invite us all and we'll have a great party. But don't get married because the state tells you what rights you can get only when you're married. It's none of the state's business. And we need to be more critical minded. We need to be more historically aware. We need to be more radical in our thinking rather than just taking on board like sheep what the state gives us as though it is a reward for us. The state should exist for us, not us for the state. And so by demanding from the state our rights, what we are getting are peanuts thrown at us. And that's one of the reasons why I don't love the law, even though I find it fascinating to see how it doesn't work, but how it really, really thinks that without it, everything's going to fall apart.
Thanks a lot, Dr. Menon, for those lovely comments. Now, taking from that tension, I would like to ask Mr. Anish, so any conversation around reform of family laws or in general ends up focusing on its conflict with personal laws by losing focus on how those personal laws end up making space for queerness or different set of identities, different set of family structures, and it just divorces it from that fact. Now that inherently creates a sort of perceived conflict between erosion of religious identities on one hand and inclusion of several other kinds of identities on the other hand. So do you have thoughts on this?
Many thoughts on this. Firstly, thank you to everyone for so patiently listening in on this discussion. I'm grateful to the team here at Vidhi for inviting me, especially to Surabhi and Kadvi, who've been very generous with their time in setting up the framework for our discussion today. I'm also not a lawyer, but I come from a family of lawyers, and family law has been a particular focus because my grandfather used to be the principal of a government law college and assisted Ambedkar in drafting the Hindu Code Bill and subsequently in public outreach required for that bill in the 1950s. So with that sort of perspective, I want to bring two key ideas to the table today. And these also draw upon my own experience in electoral politics and the sort of contested terrain that we occupy today. The first is on the nature of family law reform, and I want to turn to Professor Menon's framing of how the private is constructed in the popular imagination and its inherent dependence on consultation and consensus, for which I will turn to debates around the Hindu Code Bill and the Uniform Civil Code. And the second is the frameworks within such a consensus is built and the contested solidarities it produces, for which I want to turn to Uttarakhand's UCC and the debates before the Supreme Court's constitutional bench on marriage equality. So as we all know, the present push for a uniform civil code by the BJP, and in particular by Prime Minister Modi and Home Minister Amit Shah, represents the most wide-ranging overhaul of personal laws since the Hindu Code Bills in the 1950s. Then, as now, popular resistance to the bills has necessitated a widespread political campaign to secure the public buy-in necessary to push them through the parliament. Chitra Sinha's excellent book, Debating Patriarchy, illustrates how in the 1950s, public meetings were held across the country in support of and against the Hindu code bills, because there was a need to prove that the government had popular consensus in changing family law and had public buy-in. In fact, it was only after Nehru contested the 1952 elections with changes to family law as one of his political planks that the Hindu code bills that were then passed in parliament could go through. Now, a similar attempt is being made today in the face of renewed resistance to the Uniform Civil Code. And this general election will perhaps be a litmus test of whether the government can claim public buy-in to pass the UCC in parliament. And we might see that happening in the near future. And what is interesting is that nearly 75 years later, the perception of democratic consensus on family law reform remains essential, even for governments that we might otherwise label as undemocratic or dictatorial. Now, I want to focus now, of course, on the performance of this consensus. I don't think the government is particularly bothered by the actual creation of this consensus, but there is a certain way in which family law and debates around it require this idea that everyone is accepting and agreeing to these family, oh, wow, that's a significant difference, is accepting and agreeing to these family laws being changed. So building the perception of a consensus for any side, including a side elected to power with landslide majorities, requires the crafting of unlikely solidarities. Think perhaps of the ways in which religious groups otherwise vociferously opposed to each other came together in the marriage equality petitions before the Supreme Court to create this idea of consensus around opposition to marriage equality. Or those that spoke out about the triple talaq petitions. And Ms. Soman is here, a petition that was brought forward by Muslim women, but supported overwhelmingly by Hindu men, right? As the UCC inches closer towards becoming a reality, new solidarities will need to be crafted around the UCC as well. The Uttarakhand UCC is a classic example. And Professor Saxena, I want to take you up on that because in many ways, its provisions on live-in relationships can be made gender neutral fairly easily because those provisions are gender neutral in the statute, but not gender neutral in the definitions. And Justice Kaul might be able to illustrate whether or not this is possible, but a reading down of the definitions will be what is necessary to make live-in relationships sort of gender neutral and give you the piece of paper that everyone's been fighting for in front of the court to say that we're legally married or our relationship is recognized. Now, yet, supporting laws like the Uttarakhand UCC will undo the solidarities built by the queer community with Dalit and Muslim communities over the course of movements like the CA and NRC movement, because they will necessitate a buying into a project that has not been accompanied merely by its sort of legal apparatus, but by a rhetoric of Islamophobia that is undeniable, right? So what do you do then in such a case? Do you buy into a UCC which is giving you rights, when you know that it will demolish the solidarities that you have painstakingly built so far? I want to leave it very shortly over there because I know we're also running short of time, but I want to wonder how movements that have been crafted through rights-based activism are left sort of unsettled when the carrot of rights is dangled in front of them by someone whose politics they have historically opposed. And then does the intent of the steps taken to grant those rights matter? And then do the ends justify those means? And are alternative means even possible? And I think we need to explore these moving further. I'm happy to share initial thoughts on what those alternative means are and the ways in which rights-based activism, particularly through the courtroom, has transformed the LGBTQ+ movement over the course of the Q&A. But I want to sort of raise that initial challenge that we need to think when we think about the granting of rights through things like a uniform code bill, and for movements that have historically been built on politics of solidarity, what a rights-based framework and rights-based demands are. What rights-based demands do to these movements and the sort of limits they place on solidarity and the contested solidarities that emerge from them. So I'm going to leave it at that.
Thanks a lot, Mr. Anish. In the interest of time, we can move on to the third sub-theme right now and circle back with Q&A at the end of.
May I just interrupt
sure.
because I feel the couple of things which do bother me. Firstly, the UCC demand historically came from the women's movement. And I think it wouldn't be fair. Yes, it's been co-opted, it's been used, say that, but I think historically it denies 3 decades of activism from 1920s to 1950s by women's movement across all communities. You know, the Muslim women were there, Hindu women were there. So it's important to recognize that. The second is, I think for any legal reform, we have to be more gender neutral. Hindu men, Muslim men, women, anybody who's willing to join the process of reform in the right way would be welcome. And in fact, the process of reform historically, widow remarriage and so on, was often supported and led by men. So I feel that, you know, in making that distinction, we shouldn't be polarizing. I'm sure you didn't mean that, but I just wanted to make a correction there.
Thank you, Dr. Agarwal. Sure.
One small thing, and I know we're losing time, so I'll do this very quickly. I actually don't think I don't agree that this has been a consistent, UCC has been a consistent demand of the women's movement. It may have been the case that in 1930s, we are building towards codification, but not necessarily uniformity. And that's quite a distinction between what codified law would look like and what uniform law might be. And actually, the women's movement responded very sharply to context in 1985 with Shahbano. So the women's movement is also not operating on sort of an abstract principle. It's responding to context, and that demand really changes post 1980s. So, you know, with not just Shahbano, but also Roop Kamar. So these two cases led a lot of Muslim women's movement to actually reorient, not to distance itself from state intervention like Zakia
Yeah,
would say,
and you know,
alter-
I agree with your framing that this is a dynamic process, but I was simply correcting it that the process doesn't start with the current government. We have to go back to the pre-independence period.
Yeah, I
and
think
and so on.
this
That's all.
has the
That's all the
potential of
point.
going on.
That's all the point that I was making. And
point
I'm
is-
very familiar with the 85, having been
point is
probably
very-
very young. You were a baby. I was very much part of the movement.
Yeah, yeah. Yeah, I think Saumya is a baby in most conversations, but she makes up for it with her wisdom. So I'll now quickly hand over to Aditya.
Yeah. So I think with gender justice and queer inclusion, we've covered two areas where the interface of these subjects with family law has been quite tangible over the years and over time will become increasingly more so. What we will look at now are two different areas which have received very little attention historically when it comes to personal law reform, especially the uniformization project. The first is Muslim personal law, and then we'll move on to tribal and customary law. And to be perfectly candid, both these subjects deserve their own seminars and panels just dedicated to these issues. But to give you a flavor of what these issues might bring up in the future, we have Professor Chandra Oraon, who will address us on tribal and customary law. And we have Ms. Zakia Soman, who will take us through Muslim personal law. Professor Oraon, if you could start off by telling us a little bit about how tribal communities have historically in India engaged with the question of personal law reform. If you could tell us about the interface between tribal and customary law with principles such as queer inclusivity, gender justice, etc. And whether internal reform within tribal communities to pockets of family law is possible or not. Sure, sir.
Okay. Honorable Mr. Justice S.K. Kaul, former Judge Supreme Court, my distinguished panelists on the dais, and ladies and gentlemen in the house, very warm good evening to all of you. Well, this platform provided by Vidhi, I would say the idea, it fulfills to a great extent the idea of inclusivity that we are talking about, right? Inclusion in all the respects. So I thank Vidhi for providing this platform to dwell upon a very, very important subject and very, very often neglected subject, that is tribal and customary law. When we talk about tribe, we think of tribes somewhere in South Africa, or maybe in New Zealand, or maybe somewhere else across the globe, but we forget about tribes in India who are very much the citizens of India, and foremost citizens of India, if you go by Kailash versus state of Maharashtra. But how much do we know about the tribes? So I'll take a leaf from Justice Kaul's speech, that if we fail to acknowledge the problems plaguing the tribal communities, the more we fail, the greater the distance towards arriving to a conclusion. And we have unfortunately failed. Today, we are talking about uniform civil code and uniformity in all respect in a multicultural, multi-diverse society. And we are dwelling upon Hindu Marriage Act, Hindu Succession Act, and which have already been codified. And still, after the HSA amendment in 2005, the right which is accorded is not there in practicality. So where do we find a disconnect? Something in law not well taken by the people and not finding, adequate, implementation. So the opinio juris that I've been talking about is entirely lacking. That means any law, unless and until it is backed up by the people or is accepted by the people, is not going to help in a long run, right? So with respect to tribal customary law, the same thing is there. And tribal communities stand on a different footing. The concept of property for them is very different than the concept of property that we in the mainstream talk about. It's not about sale and purchase. The only property that they have is land. So that distinguishes the idea of property that a mainstream society has from that of a tribal community who is guided by his clan spirit. His clan is important. Secondly, it does not spring out from any particular religion, or Hindu religion or a Muslim religion. It is springing out from the social structure, from the construct of the society that they have made. That differentiates them there. And third, how much do we understand tribal society? Third is that their law is not made in legislatures or parliament. Their laws have been granted the force of law. As Article 13 says, customs and usages having the force of law in the territory of India can also be included as law. And there the tribal customary law stands because it has a force of law. It is not made, unlike other laws, in the parliament or for that matter, state legislature. So what is that force? If we bring, I very well accept that the constitution, has a great ideal of going ahead with uniform civil code. Very well welcome. And that would eventually, we would be marching towards that. But with respect to this force, where do we get this force even if we bring the uniformity? Are the people are ready to accept this? That's question number one. I stand before you not to offer you any ready-made solution. I stand before you to give you a perspective. And we have to together chart out the solutions towards that. Now, with regard to, the tribal communities, 700 plus tribal communities are there in the country. If there may be more. And we see they constitute around 8.6% of the entire country, right? 10.45 crore of the people we are talking about. So if we talk about the uniformity aspect, first let's see uniformity in the respect of their laws, which are still prevailing. Let's understand what is the society in which they are living in. Now the UCC talks about uniformity. I'll come to the questions and then we'll tell the problems. That whether there has been any discourse with regard to the reforms of customary law in the greater gamut of the family law. Now I would say in my experience, very little. I don't recall of any organization within the community raising that voice that yes, we require uniform laws. The discussion has come ahead because of the, news that yes, UCC is coming being. And then we see that with respect to the rights, some rights have been litigated in the court with respect to gender, like we said, gender discrimination. How does UCC, how does tribal customary play with respect to gender? With respect to that, we have seen cases, for example, with respect to inheritance. We can recall a Madhukishwar case in which it has been litigated. Madhukishwar was the state of Bihar, where the Supreme Court has said that yes, at that time the state of Bihar, that Chotanagpur Tenancy Act is male biased because it talks about a particular tribe, Mundari Kutkati land, in which it says the Chotanagpur Tenancy Act, Section 7, it says that the property, the Mundari Kutkati, the original clearers of the soil, their property will devolve in the male line. So there, it has been contested that why only male line, but that did not go beyond that. It instructed the state of Bihar go for some gender inclusivity, but the then Bihar Tribes Advisory Council was not ready because there was a lot of uproar. Why is it so? It is because that, so that few cases are there. Similarly, if you remember, Niti Mohan's case of 2022, there it has been litigated that they asked for, female asked for, compensation because there has been change in HSA 2005, and few other cases are there. So through the courts, there have been cases, but the cases are concerned basically on the inheritance rights of the women, but not in the society. Largely, the society is being governed by their customs in their traditional institutions. So if the UCC comes into being and uniformity which is clamped over them, it will again, there is a kind of a problem. Let me share what it could be. Today we see the community is based on different patterns of the social structure. The mainstream, you see the 5th schedule areas, the 10 states having the patriarchy. The 6th schedule areas are following the matriarchy. Even in the down south, if you go to Lakshadweep and if you go to Kerala, you have Maru Kakatiyam system. And if you go to Central Nicobar, you have a two kind of system where it is bilateral. It's based on choice. The property can be given to either the female or the male. Here the property is on the patriarchy. There the property could be given based on matriarchal way of inheritance. Whereas Machong, which is the female, the youngest daughter is the inheritors of the property. Now, if there is a law which comes and says this is this, then there is a social structure that has to go under change. Here, the 5th schedule area, the patriarchy will have to balance with that of the females, yes, and they are the in the 6th schedule areas, it will be overall of the entire social structure. Now we have already seen when Meghalaya brought the Meghalaya inheritance bill. What happened to that bill? So I was talking about the public opinion. Have we got that public opinion before we clamp and bring that particular law? That is the question that needs to be addressed. And similarly with regard to other laws, because family law does not operate in isolation. As we already know that tribal and customary law has a special place because it excludes tribal from the application of the Hindu Marriage Act because of their customs and tradition. It cannot be directly applied as long as they are following the customs and usages. At the same time, there are other protective laws in the form of 5th schedule. And whatever property law we are talking about that has the connect to their land. And the governor under the 5th schedule is obligated to protect that the land by way of you see, transfer does not go out beyond the clan or beyond the to the non-tribals. That will further pauperize them, because the only property that is available to the land is land. So, in a piecemeal way, we cannot go ahead approaching and bring uniformity. I would agree with 21st Law Commission, because for other laws, there has been a number of years of codification. Have we ever thought of codification, or even for that matter, documentation of tribal customary law? Where was the government sleeping? If UCC was the target, you had to undertake this task much long before, or parallel to that of other laws. We haven't done that task. All of a sudden night, there will a law which undergoes change and everything will come under the sum. Would we be able to manage the kind of tensions that it will brew, minus the public opinion or the opinio juris which is there for customs? So my purpose is to enlighten you as to the challenges that are there, and suggest that it has to be done in a uniform, in a step-by manner. First, talk about documentation. We do not know, even the court refrained from touching upon the tribal customary law because they do not have anything to guide. Nor we do not know about what is the custom prevailing in this particular tribe or that particular tribe. So unless we know, how do we give something to the tribe? So first, certain suggestions is to go for documentation. Then give the community the chance to reflect back on their laws on the criteria of gender justice and other things which are enshrined in the constitution. Let them debate and discuss. And then you can go for codification. And on that codification, thereafter, you can get the opinion from the different tribal communities, a sort of a referendum from them, major tribal communities, and then you can say that, yes, we can now go forward for uniform civil code.
Professor, in the
But
interest of time,
this is not the hour, the right time, we will have to wait for that particular moment, and we have to do our own homework before we bring any uniform laws. Thank you.
Now, all of you will be interested to know that Vidhi is not the only institution drafting family laws. In 2017, the Bharatiya Muslim Mahila Andolan prepared the first draft of the Muslim Family Act, one of its kind, with provisions on marriage, divorce, maintenance, etc. So if we can ask Ms. Soman to tell us a little bit about how you went about preparing that draft, what the response of the community has been generally, and if we want to achieve gender justice and queer inclusion in Muslim personal law, how do we go about it?
Thanks, Aditya, and thanks, Vidhi. I'm very happy to be here. I'll begin by saying that Muslim women are amongst the most marginalized citizens of India today. They are marginalized at home, within family, within community, in society, and increasingly in the nation, thanks to the politics of polarization, which is in fashion so much today. We are ostensibly governed by the Shariat Application Act of 1937, but that act does not include any of the important aspects which govern the life of a Muslim woman. That act does not say what will be the age of marriage. That act does not say what will be the procedure of divorce. It doesn't say whether polygamy is legal or illegal. It doesn't talk about what about custody and guardianship of children. It doesn't translate so many affirmative provisions which are Islamic, such as consent, such as meher, such as nikah nama. It doesn't mention that. And we are told whenever the Muslim women raise their voice for justice, they are told that you need not speak anything because Islam gave equal rights to women 1400 years ago. So that's the response we have been, given always. But it so happens that in the last about 20 years, a lot of Muslim women have started speaking out about their condition. lot of Muslim women have started demanding their rights in marriage and in family. And that's how the petition went to the Supreme Court in 2016. It's of course, there was some discussion here also that ideally, we also believe that there should be a codified Muslim family law. And the least we are entitled to is legal parity with the Hindu women and Christian women, all other women of our country. But initially, we were only talking about that we need a codified Muslim family law. But we realized down the years that that may not be possible. And that's when this whole issue of triple talaq started coming up from so many women across so many states. And then that's how it reached the Supreme Court. And then we all know what happened. So there are so many issues involved here. One is we have to keep in mind that this is the largest minority, which is also very poor, which is also deprived socially, educationally, economically, politically. And there's a lack of a democratic leadership within the community. And who are the arbiters of justice, and who are the go-to people in all matters faith, under which personal law falls? They are the clergymen. And clergymen everywhere, irrespective of which faith background, have a tendency to be misogynist and patriarchal. We all know that. I don't need to sort of dwell any further on that. So as it happened, all the kind of practices, be it triple talaq, be it polygamy, be it halala, be it denial of guardianship and custody of children to the mother, they are all based on interpretations or misinterpretations by these clergy, which have become the norm and which have become kind of law in our country in the absence of codified law. So it was in such a background when we thought that we as women need to take the initiative to answer, Aditya, your question particularly, that if we ourselves don't take the initiative, nobody else is going to take it on our behalf. And there's a larger problem. The larger problem is about the way Islam is understood and practiced in our part of the world, in South Asia and in India. Because our book is in Arabic. And growing up, we all read the Quran, but without understanding it. We just literally read it. We don't know the meaning. Hardly anybody undertakes the effort to, read the translations. And majority of the translations are, again, made by the same patriarchal, misogynist scholar men. And the progressive translations are, those copies are rare to come by. And most people are not even aware that it's a matter of interpretation, and there can be very positive, gender just and progressive interpretations, such as, done by Professor Amina Wadud, our own Asghar Ali engineer. I'm sure many of you have heard his name. So the way religion is understood, approached, practiced, that leads to this whole problem of male dominance and injustice to women, and that is how it has gone. So, for instance, take the question of our draft law proposes that the age of marriage should be 18 and 21. Because we feel that when it has come in the laws of the other communities, a lot of application of mind has already happened there. But in our understanding, marriage age is puberty. Now, what is the meaning of puberty? Is it just the physical attainment of certain attributes in a girl? On the other hand, marriage in Islam is a social contract. So can a girl of 15 who has as such attained puberty, is she competent to enter into an important social contract such as marriage? We need to ask that question. Take the question of polygamy. Because I'm very clear, and even in the BMMA draft, we are very clear that in today's context, polygamy is just not permitted by Islam. Because polygamy was permitted under certain strict conditions of those days, but it was never encouraged. And today, by all accounts, none of those conditions prevail. So if anything, the sex ratios are so poor. although Muslim community's sex ratio is better than the other communities in our country. Today, a woman just, her sole means of survival is not just marriage and husband. She even if she is single, even if she is widowed, even if she is without any family, she can always empower herself and build a life for her own. So there are so many such reasons which do not permit polygamy in today's context. Same with guardianship and custody of children. There are so many interpretations which allow full sort of rights to the mother. So this whole arena, it has got so politicized. Unfortunately or fortunately, when the triple talaq matter went to the Supreme Court, there was the NDA government. And I have to say, although I do not agree with most of their policies, and like you said that it's the most, it's a government which is not very democratic, but that is pushing for UCC. So I have to appreciate that in the triple talaq matter, they filed a reply supporting the abolition of triple talaq. So many progressives feel that this is not the right time to talk about justice and equality for Muslim women. But then the Muslim women themselves are asking that there is never the right time for justice and equality for us. Because I cannot visualize the triple talaq petition, if it had gone to court maybe in 2008, 9, 10, what would have been the outcome? I'm not sure about that. So yeah, these are all larger political debates. But I must say that legal parity for Muslim women it's high time, it's long overdue. And resistance to reform from the clergy and certain political sections has to be now its bluff has to be called out, because the triple talaq movement received support from almost the entire community, barring some sections which are conservative, barring those affiliated with the personal law boards or the Imart-e-Sharia, whether some such bodies. Lots of people came out in open support, but unfortunately that momentum for reform was lost in the wake of the political developments which took place later on. And as I said, as the country got more and more polarized and the onslaught grew greater. So yeah, that is where we stand. So I feel ideally there should be codified Muslim family laws. But of late, I have come to be of the opinion that if that were not to happen, then UCC will be our best bet. I think I'll end there.
Thank you very much for that perspective. And I think, as you can see, inclusivity takes time. So we've actually managed to get a range of perspectives, and you've been an incredible audience for sitting for this long. And if I were to say that if we could just concretize this into 3 themes, and there is a tension here as to whether we should double down on these themes or we should roll back. The first is the role of the state. Should we look to the state to be actually guaranteeing greater rights, and look to the state for stuff like registration, or like Madhavi was suggesting, maybe slightly anarchically move a little bit away from the state, and maybe there's a lot of merit to that as well. The second is the role of codification, and the question of, we know that codification was a colonial project, but is it time to give up on that colonial project and look at other projects, or is it time to double down on that and look at something that is more queer inclusive and gender neutral and genuinely inclusive of other diversities? And the third itself is more, a kind of abstract version of that, which is the role of the law itself. I think somewhere there is an implicit assumption amongst us lawyers that the law can be a force for social good, but should we be looking at a different site for these kinds of changes? I think these are 3 themes that I've found emerging across the various speakers. But I'm going to stop here, and you've been an incredible audience, so I think it's only fair that we turn to you for some views and questions. We've got about 10 minutes or so before which we finish. This clock is 10 minutes fast. The IIC is never ahead of its time except here. But we have time for a few questions. So please do raise your hands and ask them. Yeah, there's one there and one here. We'll just collect a few questions, and if there's a mic that can be taken, maybe you can just take this mic, and we have enough.
Hi, hello. Thank you so much. That was an absolutely fascinating spread of opinions on a number of very specific points and issues. I'm somewhat come from, as a student of constitutional law, I come from a school where I like to look back and forth between these specific issues and the broader principles that we can think about. And here I want to just ask you about a very, I thought, a very relevant broad principle that comes up here, which is the right to non-discrimination. My sense has been that on the question of family law reform, the existence of different sets of rules for different religions and different communities, religious and customary rules, in a sense, if we see it, it treats people differently on the ground of their religion. And in this sense, there is a direct need to discuss this in the context of Article 15. And I have found that because of a number of reasons, mostly technical constitutional law reasons, we don't have clear ideas about why this is justified if we were to look at it from constitutional law. Three candidate reasons. One is Article 13, a technical sense that, yeah, I mean, I just wanted to preempt these three because the idea that personal laws are insulated or uncodified personal laws are insulated from judicial review. If they violate a fundamental right, that's fine. It's the Constitution says it's all right. The second is that it supports religious freedom, that there's a separate right in the Constitution for religious freedom. These personal laws support that freedom. This is again contested by people who say that rules cannot support freedom, rules only constrain freedom. So a personal law cannot be considered a form of religious freedom, but I'm still very sympathetic to that idea. And the last is the idea about what has been mentioned by some speakers, which is that each form of personal law gradually be harmonized, gradually be reformed together. I just sense that if these sorts of justifications are used to personal law, it could also be used for other forms of religious discrimination. Prime amongst them is the CAA, where a particular step is taken for one religion or a few religions and not for other religions. And the justification given is that we can go religion by religion. We don't have to cover them all in one go. Is there something we can think about as a good reason why the accommodation of religious practices can go to the extent of entire bodies of law called personal law from constitutional law?
Yeah, this is a bit hard, but we have a question here. We'll take a few questions together, but please do try and keep them short.
And I hope women will also ask questions.
Of course. First of all, thanks to Vidhi. Like, Justice Kaul is an inspiration for me. So it's like a dream come true that I'm talking to him. So my question to you, my Lord Justice Sanjay Kishan Kaul, is is Special Marriage Act violative of Article 14 and 15? I'm not a law student, so I want to know. And you just mentioned that your lordships have used Article 142 quite liberally. So why not in this case of same-sex marriage, where you could have brought the weak queer people in the equal pedestal? That is it. Thanks.
Yeah, there's one there and one here.
Hello. Yeah. Hi. So my question is a two-leg question. One, two on the both sides of the spectrum. One would be to my lords, Justice Kaul, and one would be to Anish. So firstly, on the legal side, lordships, I had the privilege of being a part of the Suprio case under senior advocate, as his lordship then was Justice KVV. Now Suprio has come, and according to me, having been the part of the case, it has done on the adoption side and on a lot other sides on the majority has done more harm than the good, which was already there on the Kara circulars and having even constitutional bench having held on the adoption part, it not being there at all for even the single parents and for the non-heterosexual couples. So my direct question is that how do we look towards the Supreme Court and the courts if we or when we feel like to ascend those stairs again? On what instances should we look towards the court that even on those same instances of marriage, adoption, and anti-discrimination, be it independent cases, and how will we be taking it forward in that spectrum on the court's aspect? Secondly, my question would be to Anish in the aspect of policy. The Supreme Court and the Suprio has passed the baton to the legislature again, from where we came to the Supreme Court on passing all those laws be it on marriage or be it on anti-discrimination. Many political parties this Lok Sabha election have come with many manifestos which pointed out some lines for LGBTQ couples or non-heterosexual couples. So how do you see it? Is this just a queer baiting thing? Because the same governments in 2013 and all, when Suresh Kumar Kaushal came, was vehemently opposing even the 377 abolition, and the current establishment did not oppose the same in 2018? Or is it an actual thing we are looking forward from the same parties, and it's not just a queer baiting technique?
So first of all, a very cheerful evening to everyone, and my heartfelt gratitude to Justice Kishan Kaul, because he's been a great inspiration, and like all the judgments, a lot of judgments that I've heard, they've deeply resonated with me. So with that, my first question would go to Justice Kaul. So, you said that about, so you said in case of Muslim marriages, like a lot of times they're away from legislation, and there are these issues of maybe child marriages or halala or like violence and polygamy. So recently we came across one fascinating thing in law school, which was the interplay between the option of puberty, Khyarut Bulug, and the POXO Act. So in case of child marriages, like one of the deterrents, which is one of the evils of child marriages, is considered as sexual intercourse, premature sexual intercourse. So certain state high courts have taken various initiatives through POXO Act to kind of harmonize the sexual aspects in child marriage, so that that one evil of Muslim marriages, like child marriages, is reduced. So is there a way through which POXO Act can can POXO Act effectively mitigate the issues of arising out of Muslim child marriages? And can this decision someday be adopted by the Supreme Court? Then my other question goes to Oraon, sir. So, sir said that customs have not been like documented or codified for a long time. And then in that ways, UCC would certainly be a hurried approach. But since this whole issue of customs is like customs have been going on for a long time, and they've also had a lot of impurities and adulterations. So how do we ensure that the excess of documentation happens very effectively, and it happens in a manner which is not biased or ideologically inclined, and that in the end justice is preserved in the process of documentation? So how do we ensure
Thank
that?
you. We got that. There's just one time for one more, and we just take.
Thank you so much.
Okay, now there are three more. We'll take one here. We'll take one here. You had your hand up.
Good evening, dignitaries, and everyone present here. So
Just keep it very short.
yeah, I have a very quick question. As ma'am, Malavika ma'am just mentioned that for any law which is being misused by women, is becoming a havoc in the society, and it's being pointed out by the judicial system as well as the parliament. And so my question is regarding 498A, where again the Supreme Court has asked the parliament to look into the same, as to there should be a shield to the husband as well. So what kind of a shield that we may look forward to?
Great. That's nice and short. We will be inclusive if you make it very, very quick.
Yeah, I'll just keep it very brief. So my personal belief is that by excessive state legislations and many interpretations by the judiciary, and my personal question to being a Justice Kaul is, do you think so that today we as the state are stuck in a situation where we need to legislate and interpret every situation in context to live-in relationships, and how it leads to, under the UCC Act, how children, which is being left out, and it raises a big question on under whose custody they will go under. So my second question is, and which I found it quite unfortunate, that none of the people in this panel discussed about ecofeminism and how family in the coming time is going to discuss about climate and the sustainable development.
Another seminar for that one. Last one. Yeah.
Perfect.
Very short.
Yes. So my question is posed towards Ms. Rajkotia and Ms. Agarwal. Ms. Rajkotia, as you recounted the case about your client, I'm reminded of the concept of digital poorhouse, which is very similar to the legal poorhouse that women in this country go through. For example, if we take the example of Section 9 of HMA, how a supposedly gender neutral section, as has been noted by Professor Upendra Bakshi and Professor Vijayendra Kumar as well, that how it is technically used by men more as compared to women, if we talk about the factual equality of the concept. So do you think that just like a digital a digital poorhouse, a digital poorhouse in some sense has been defined by Professor Eubanks as how digitalization in some sense facilitates poverty. So how and my question to
Very short.
very brief, Ms. Agarwal, is that you talked about the drift when it comes to mothers versus daughters in perspective of the 2005 amendments. Yes, widows versus daughters. So in that perspective, does it also create a legal poorhouse wherein it is creating a rift? If we talk about the rights of women in property, in some sense, it snatches away property from women rather than.
Thanks. So let's just go across from here, because I think there's about one question for everybody. So Anish, I'll start with you. Yeah, there's a mic here. Just pass that one. Yeah. Yeah, just a few. So whatever was.
So onto your question, right? I think
one.
it's a very difficult choice. In many ways, the BJP has been the only party, or the party that's thought about queer rights more than anybody else. Whether they've done more about it, whether that intent has been valid or not is different. The BJP has thought more about it, and with acts like the Transgender Persons Protection and Rights Act, flawed as it might be, done more on that front as well. There is a very real possibility that the BJP will be open to engagement on queer rights. The question is, what solidarities does that engender? And do you voluntarily enter into those discussions and those negotiations? And we fall on different sides of the spectrum within the queer community on that. I think the second thing is, where does it leave us with respect to political parties? I think a political party, when it lists you in the same category of people as the sort of differently abled and others, is putting you in a category of charitable rights. It's putting you in a manifesto in a category of people who are not able to generate the kind of coalition building required to make the sort of rights-based demand a demand rather than a petition. This is why I disagree with court-based approaches. I don't want to approach a court with a petition. I do not want to plead before a justice for my rights. I want to demand it in front of a politician. The reality is that the queer community is a small community. The only way to effectively demand for that is to create solidarities and to create alliances that create a charter of demands and not singular demands that then get taken seriously in the political arena. Both of those are in direct conflict with each other. If you choose to create solidarities that prevent those coalitions that will lead to sustainable demands for rights, you're choosing the short term. And to quote Bon Jovi, I want it and I want it now, because we ain't gonna live we're not gonna live forever. So, there is that justification. I don't want to wait forever.
The cat is now out of the bag. Yeah. Professor Oraon, that question about documentation, how do we do it well? Very briefly.
Yes. Very important question you have asked. And this is what we have not been doing. It has been long that documentation is due. Whatever documentation that is available right now across the country is in the anthropological records. So from legal perspective, there is very few records that is available. And when you talk about custom, as the court applies the jural test, antiquity, certainty, uniformity, all those things, not opposed to public policy, all those things. But how much of these things have we been able to retain? With the growing, influx of people here and there, and with the culture getting assimilated, the purity of those things is getting lost. So it is high time that the government, yes, as well as the people should come forward, because otherwise the purity of the custom will be lost. And that is the first thing, is documentation. We can think of codification later on, but we do not know what law applies to them. We only know about inheritance. Do we know about marriage? Do we know about how the adoption system is? Do we know about guardianship? We have very little information about it. So the better, earlier, the better.
Right. And I think that's a fair point because even the Uttarakhand code just leaves tribals out because I think part of the reason is the lack of knowledge. Soumya, you want to take that first question?
Yeah, I was actually going to not tackle Lalit's question, but respond to it in some way. So, religion as the basis for difference. I think the tribal question again becomes important here because almost all drafts of UCC leave out the tribal questions. And by tribal question, I also mean the regional question because they leave out the Northeast in a very significant way. Now, I think that the tribal question really lays bare the true antagonism between uniformity and and justice, right? So in one and federalism and democracy as well in that sense, right? So for me, I think movements speak in different voices, and that is valuable because I would want Zakia to ask for a codification of Muslim succession. I would also want the marriage equality petition to go through because movements, it's very hard if you look at the histories of these movements to make them speak in one voice. And I think this is how jurisprudence moves forward. Sometimes it's 2 steps forward and 3 steps backward, like the transgender bill. We don't know if it's a great one, but it is a step forward. It could have also been a step backward in some way, but I do think that the point in history that we are at right now, it is very difficult to find an absolute consensus on things. So we have to actually capitalize on this difference, and this basis of difference can actually lead to very, very different outcomes over time. And sometimes you can really make the law mean whatever you want it to mean in interpretations, and this ambiguity has served us very well in family law jurisprudence, particularly when it comes to judicial interpretations of religion and so on and so forth. So I think difference is quite valuable that way.
Soman, you want to take that question on Muslim women and child marriage? This is not a problem with Muslim women, of course. Child marriage is generally an issue across the board, but maybe you want to say something.
Yeah, so there are several judgments of different high courts upholding the marriage because it's a Muslim marriage. But the purpose here is not to criminalize the marriage. The purpose, the intent is much greater to build an understanding about what should be the right age of marriage, both for the boy as well as the girl. And that should be based on the circumstances of modern day living, rather than caught up into some kind of misinterpretation of some ages past. So, but I don't think POCSO is the right instrument here, because that would straight away mean criminalizing every marriage which is underage, which I do not think is the purpose.
Ms. Agarwal, the question on the
Yeah, okay. So it's not a question of creating a rift because the law is not being implemented for daughters and very rarely for widows. I think there are two issues here. Firstly, lawyers should talk more to economists as well. That all the evidence of why it's so important that women have rights in land and property, not just in India, but globally, and the documentation has really grown and grown, is that it makes a huge difference to child survival. It makes a huge difference to the family, to the reduction of destitution, the possibility of poverty among women, but also whether children are educated or not, and so on. Because women use incomes and property very differently from the way men use it. Fathers use it versus mothers. Now, if you give that, then it's very important that women inherit earlier in their life cycle, rather than when they are 56, 80, when they're widows and as daughters. And I think this is the bigger question, that you keep changing the property law, but you don't actually address the fact that daughters are not. Now, it's worth asking, and I don't have immediate answers, but I think one of the issues is really about stability. This question, excuse me, is about stability. And it comes in your, you mention it in your code as well, because there's a recognition that because divorce is so low in India, I think it's less than 2% or something in formal terms, that the assumption is marriages last. Even though they're oppressive to women, marriages last, and therefore the widow becomes, more a claimant to the right than a daughter who will move away and marry somebody else, go into another village, go into another family. And so perhaps that is the factor where socially you continue to support the widow versus the daughter, even though in a larger social good, what you want is women to inherit much earlier. Just want to mention one other thing, if you don't mind, Dr. Sengupta, which is that because Zakia had raised it, I'm very happy to hear that they want to take it forward. In 2005, after the Hindu Succession Amendment Act was done, and in which I was very involved, I actually wrote in the Indian Express and had a petition and drafted a bill for removing the discriminatory clause on agricultural land, which was signed by hundreds of people, including all the progressive engineer and others, and the Muslim Personal Law Board supported it. I took the whole dossier to Dr. Manmohan Singh, and this was still 2005, remember, when the first UPA, and they didn't take it forward. And they said this is a sensitive subject, although they'd done it for Hindu women. So I think it's the problem is not just which political party, but somewhere there are other barriers. And I actually shared the whole dossier with the Muslim Personal Law Board lawyer a year later, saying, because I'm a Hindu woman, if that's the issue, just take it forward. Forget that I created it, take it forward. And it just didn't go forward. So maybe Zakia and I can work together, and you can take it forward.
So Malvika, we'll just come and end with Justice Kaul, the question on 498A and
So Agnesh Kumar deals with it. It's enough of a shield. And basically, there are enough in place for the protection of men, really. And with regard to your question, yes, Section 9 is gender neutral. And yes, men have misused it more. And the Supreme Court has allowed it in the Saroj Rani case when it had an opportunity to fix it. And that still continues to be good law.
Last word to Justice Kaul. There were a number of questions directed at you. I'm trying to paraphrase, so apologies to everybody. But I think the basic essence is that when does the queer movement go back to the Supreme Court, and what can they expect from the judiciary now, in the aftermath of the Supreme judgment?
So, thank you for some of the compliments and also the barrage of questions. One of the things this young man posed was, and I recollect, was Article 142. As you said, you're not a student of law, but the fact is, it is what we call the Brahmastra with the Supreme Court. It is meant to cure problems in a given facts of a case. It's not normally to lay down law which will apply across the board. So where we feel it is, there is a great injustice arising, that one power is given to cure in the given facts of the case. So it is normally not used for law purposes, other than it has been used in mutual consent divorces, also in where consent is not there, but there's an irretrievable breakdown of marriage in the given factual situation of the case. Now, the debate why it went to Constitution bench was only because it was felt that can they do it at all or not? So that's the general proposition on which it was ruled, not otherwise. Yes, I do believe the queer movement thought they were very near in it so far. Let me say that's what has happened. It does happen in law. After all, if you see the journey of the earlier matter, it started with the admission. I don't know whether you're aware, it was dismissed in limine in the High Court after that. Went to the Supreme Court, remitted back, and then a particular thinking process of the judges got the judgment. When again it came to the Supreme Court, a different judgment flew. They kept on agitating on the issue in one form or the other. Now, understand, judges are social creatures also. We all have also, our objectivity of law also are governed by our background, our thinking, our social thinking, importantly. So it has changed depending on which side the thinking of the judges went. It is one of those cases which is very judge dependent, honestly. Well, they thought this was the time, this was the moment when they could have got it. They were fairly close. The minority took the view that, well, the Special Marriage Act had its own connotations. And the complexity pointed out by the government in bringing within the Special Marriage Act. So make it a civil union, make it something different, but give that benefit what was being asked for. It went 3:2. I still believe there is a review pending, there is other things pending. I feel it's a process of time. As the churning will continue, as it has continued, I feel confident. May not be now, I can't predict the number of years, it's 2 years, 3 years, 4 years, this journey went for 10 years, but I do believe that somewhere it'll be earlier than later that this recognition will come. If the legislature does not play the role which was expected to be played in view even of the minority judgment. The majority judgment, of course, did not do so. I wish and hope the legislature plays it, because that can give a better scenario to the given facts of the case, and maybe find some methodology to do so. Is there any other question which I have forgotten in it?
No, I think you've covered everything. And just Surabhi, last word quickly to you to close us for this evening.
Thank you, Dr. Sengupta. So in its course, this marathon discussion has spanned across the areas of gender justice, queer inclusion, and minority rights within family law, often touching on the very important intersectionality of these three spheres. As a vote of thanks, I would like to extend our deepest gratitude to the speakers for once staying throughout, even flying in, driving in, for their valuable insights, and the audience for engaging so thoughtfully with the discourse at hand. A special thanks is also extended to IIC for so graciously offering the venue, and to our lovely moderators, Kartavi, Rakshita, and Aditya, as well as Namrata, for putting it all together. We hope to keep engaging with the question of family law reform. We hope that this is just the beginning. As mentioned, Vidhi's model code on Indian family law is now live on the website. You can find the QR codes all around and scan them if you wish to engage with it more. And thank you all for attending. We hope there can be future events as well to keep this discourse as alive as possible. Thank you.